Thank you, Mr. Kennedy. Deputy Corcoran-Kennedy.
Thank you very much, Chair. Thank you for your presentation here today. I'm interested in the Fall to Ireland report that you quote in terms of the potential impact on tourism. Do you have a title of that report? I'd like to follow up on that.
We don't have the title of that report at the moment, but it was a draft report which has been circulated approximately 2 months ago, which refers to the 24% unfavourable response when tourists were surveyed at particular tourist locations. We don't know the question, so we really can't comment very strongly on that. But certainly a reservation we have is that right now the current situation is approximately 1,250 turbines installed and operational in the country. We believe between to meet the 2020 domestic targets and also the export targets, that there will be approximately 3,500 additional turbines to go. So what 3,500 additional turbines in addition to the 1,250 will do to the tourism impact in the country, which, I believe on 2012, it was a €5.7 billion industry in Ireland. So quite a significant impact. But we can follow up with you certainly afterwards to get the title of the draft report and some more information to you on that.
Okay, I'm going to get started. I just have a question for Mr. Bodler, please. You referred to the decibel levels, and I understand it as being a measure of sound, but to me sound is loud and quiet. That's really it for me. When you refer to decibel levels of 43 to 45 and 107 to 110, can you tell me what kind of sound that would be in terms of something that I recognise, like, a doorbell ringing or a vacuum cleaner or something like that, just to put it into context for me?
Yep. Yes. Well, first of all, the 107 to 110 is probably a bit confusing, because that's the sound noise level at source. So you would only get that if you were standing. Well, in the case of a turbine, because the source is so big, that noise level is spread around. But that's how we calculate what the noise level is going to be at the receptors. That's our starting point. So that's a sort of fixed decibel level of the turbine itself. But that's not the level that you would get in communities. You would never get more than 55, 60, even underneath the turbine itself. So that would be perhaps one example. 55 or 60 decibels would be what you'd get underneath the turbine. Levels in rural areas, quiet rural areas at night when there's no wind, would be typically about, if you're quite away from roads, main roads, then you'd be talking about 15 decibels. And during the day in rural areas, quiet rural areas, you might be about 25, provided there's no roads nearby. But as soon as you get close to roads or other activity, you'll be talking about 30, 35, and even more than that. As you get into towns, you'll be talking about 50, 55, that kind of level. And notwithstanding what it says in some literature, the noise level in a quiet bedroom, for example, is typically about 20 decibels in a rural area or even a suburban area. So 40 decibels is, and as I said earlier, 10 decibels is a doubling of loudness. So if you're talking about levels of 15, 20, 30 decibels in a rural area at night, then 43 decibels is obviously a lot louder than that by a factor of 2, 3, or even 4.
Just to, I suppose, to help me get into my head what kind of measurements of sound we're talking about, like say 45 decibels, for example, what would that be the equivalent of in something else rather than a turbine? What would it sound like?
Well, it would be, for example, if you were close to, well, if we take a motorway during the day when it's busy, that would be the sort of level you'd get at about 500 meters from the motorway. guess that, but it would be somewhere in that region of 500 metres. And as you get further away, obviously it falls off.
Yeah, that's great. And the other question then is just to Dr. Hanning, to define what low-frequency noise is. You know, what frequency level are we at that it's considered low in terms of what we hear orally ourselves?
You should direct that question to the Cion Corla.
Apologies.
You should know, I said you should direct that question to the Cion Corla. Dr. Henning.
Can I actually partly address your first question? And that is, it's not just the absolute noise level, it's the character of the noise. And the characteristic of wind turbine noise is it's what's called impulsive. It's the sort of dripping tap. And it's the character of the noise. It has similar characteristics to alarms, and in that it's an intermittent noise, and a fire alarm is designed to wake you up, and which may be one of the reasons why turbine noise seems to be kind of waking people up, because of the characteristic. Coming back to low frequency noise and infrasound, I actually would like to turn that one over to Mr. Bowdler, because if you want the actual numbers, essentially, I mean, low frequency is this sort of bass rumble, and infrasound is below the theoretical level of hearing. It does seem as if the ear can actually respond to noise or react to noise which we wouldn't normally hear. It may depend upon what other noise is around at the moment. Mr. Bowdler, do you want to
Yes.
give an actual number?
Yes, there is a bit of confusion about low-frequency noise and infrasound. If we take infrasound, and can I also bring vibration in, because that gets muddled into it as well sometimes. When we talk about vibration, we're talking about vibration which is transmitted through the ground. So it's nothing to do with what we hear with our ears. It's to do with what we feel with our bodies when we're lying in bed, for example, or sitting down. As far as infrasound is concerned, that's generally thought to be any sound below 20 hertz, and it's usually 20 cycles a second, that is in old terms. And that is, it's quite a lot lower, for example, than the sort of hum you get from a piece of electrical machinery. And it's generally thought to be the lowest level at which you can hear sound, the sound is audible, although in fact you can hear it low and low. So anything below 20 hertz is called infrasound. There's then another section between 20 hertz and 200 hertz, and if I say that 200 hertz is about the A below middle C on the piano, so it's fairly low. Anywhere between that is generally called low frequency noise.
Okay. And it's to Ms. Fagan. The people who have signed the options, if they signed them in good faith and based on the information that they received at the time, and they want to now revise or review their position and maybe decide that they want to opt out of it, what avenues are actually open to them legally, if any?
Well, I can answer that question very specifically because I'm aware of many farmers now who want to pull out. I'm aware of many other farmers who have informed the wind farm companies through their own independent solicitors that they want to pull out. And unfortunately, in all cases to date, of the cases I'm aware of, all farmers have been advised that they're going to be sued by the wind farm companies. So it's a pretty bleak situation at the moment for the farmers, which is one of the reasons why it's incredibly important that this amnesty is put in place for those farmers who signed in the absence of proper commercial, legal and health information, that amnesty is arranged or organised for them through their appropriate lobby groups. It's terribly important.
Just one other, how could you expand on that? How do you see that amnesty actually working practically? If I'm a farmer who signed this and I want to get out of it, how would that actually work for me if there was an amnesty?
Well, I can only speak for the farmers that I've spoken to and dealt with, and they're very clear that they want to pull out. They don't want any further wind turbine development on their farms. Unfortunately, a lot of these options have been registered as burdens on their folios, much to their shock, which means that they can't even sell a site. They can't dispose of their land to their families. If you can imagine that land, most agricultural land is passed on through inheritance or through gifts through families. These options, because of the impact on capital acquisitions tax and on the agricultural reliefs on land, the land is converted from agricultural to industrial, therefore the reliefs are lost. So I think that this has to be taken up at an extremely senior level because of the potential devastation it can affect on the current farmers, the farming families. We're not just talking about some rural pockets in Westmeath. I've spoken to farmers in all 5 counties at this stage. And this is something which needs to be taken up at a national level.
Deputy Cowen, and then we have 2 more after that.
Thanks, Chairman. I get to questions. I think for the purpose of the record, maybe it's important to give some context to your visit here today, and I welcome you here and I acknowledge the efforts that you're making on behalf of your communities further to many meetings that you've held. And I know you're only representatives specifically in relation to an area in Westmeath that you mentioned, but obviously, as you've said, Nora, you've spoken to others in other counties, and I know you're cognizant of many other public meetings that are taking place throughout the 5 counties that you mentioned. And first of all, wind energy is one of a suite of alternative energy sources that are necessary, whether it be with biomass, solar, wave, gas, etc. And it's the job of the CER, as you know, to guarantee safe means and access and method of producing energy to improve choice and competition and ultimately benefit the consumer. Now, the Midlands region, as you well know, particularly and historically, is synonymous with energy generation, energy and power generation, with Bord-na-Mona and ESBs being to the forefront of that. And as you know, the peat supplies are diminishing. The PSO payments to Bord-na-Mona are due to expire in the coming years, and alternative uses are required for our cutaway bogs. And there is the potential for a jobs dividend in these developments, not necessarily to the extent and that might be being portrayed by many of the companies who are pursuing this line. And there is obviously the potential for a local rates dividend to the local authorities concerned, so that they can have at their disposal new sources of income in order for them to deliver the types of services and facilities that cannot unfortunately be delivered in the sort of manner that many of our councillors would have hoped and many of our public expect. Now, for this whole process to move forward, it's obvious that progress has to be on a consensual basis rather than it being by imposition on any community in any section or area of the Midlands. And it may be that, in my opinion, to be quite honest, that the memo of understanding that was undertaken by the government with their counterparts in the UK was overstated and maybe too presumptuous with regard to the timescale and the level of export that may eventually or be potentially explored and possible by Ireland to the UK. And I just want to take up the point in relation to moratoriums. And it's very pleasing to the ear of many for that to be muted and discussed and possibly pursued. Is it constitutionally viable for that to be the case? Is it not the case that anybody, irrespective of who they are or what they are entitled to make a planning application to a local authority? It might well be thrown out, but they have that right. And I don't know if we can interfere with that process. I think it's only right and proper that the correct legal advice in response to that proposal is out there. You know, many counties were very responsible in their own development plans and the means and methods by which they dealt with this issue. I know in my own county as a county councillor back in 2009, we devised a wind energy strategy, with designated areas within the county which may be suitable to be considered for applications. And in the context of being considered, it's up to the planning authorities thereafter to adjudicate on the various issues that you've discussed heretofore today. Now, it's very worrying to think that many of these companies that you've mentioned, and there are more than two, that they then consider approaching landowners outside of these areas and make commitments and promises to them that they may not be able to keep, and almost have no regard for the efforts that were made by local authorities in designating areas and putting forward a proposal that where applications might be considered, and to think that they then go elsewhere with pursuing landowners. And I would ask again, Nora, in relation to what you just said, from your experience, and you know, unfortunately we can't interfere with the commercial realities of these people knocking on farmers' doors and behind their own doors, sitting down and making agreements and devising contracts and so forth. But is it not, are they not legally bound before they commit the farmer or the landowner to an agreement to advise that landowner that they should seek legal advice before committing to what's on paper in front of them? And if they haven't done that, are they not abdicating a legal responsibility that they have? And if so, how void is any such agreement that they agree to? So I'd like a response to that. The other thing is, you know, local authorities, then you've had advancements in size and technology of these developments in recent years. And if you look at wind farms in Donegal or in Corcoran-Kennedy at present, obviously what's proposed in the Midlands by virtue of where we are and the height they have to get in order to attract the wind are far greater in size. And the advancement in size and technology is not represented in the existing guidelines, and that's why they have to be amended. And I would ask, you know, we're awaiting the whole process as initiated by the Minister in relation to large-scale developments for export, and new guidelines being put in place to meet that. But there should be no distinction in any new guidelines that are devised, large-scale or otherwise. There should be no distinction. The guidelines must be cognizant of the advancements that have been made, and they must be cognizant of location and setback and impact on the environment and on properties and the health implications and so forth. And there must be adequate weight given to local authority development plans and the efforts by the councillors on behalf of those they represent to be responsive in the manner in which they put policy and designate areas. Because none of them are, no more than yourselves, are against wind energy. But they only want a responsible means and method by which it's provided for and by which we can all benefit thereafter. And to that extent, you have an effort by my own county, for example, recently in their efforts to tighten up their development plan with a view to the next phase, seeking for buffer zones of 2 kilometres from the core of towns and villages. But that, some will tell you then, well, that doesn't cater for the one-off house out in the countryside, and how you get a happy medium in that regard. So there's a responsibility on the department and the minister of that department to have the guidelines in place as soon as possible, not only for large-scale developments, but for any such developments, because it could be construed that the local community may wish to avail of wind energy as a means by which they can pool together to reduce their energy costs. But the cynics will tell you, if you allow that, they're open to be bought up by these big developers in turn, and it's a means by which they can gain access to the market. So there has to be, so leadership has to emanate from the department in this regard, and adequate weight, as I said, would you not agree, has to be given to local development plans. And the efforts, as I said, by local councillors who are at the brunt of a lot of these public meetings and trying to be responsive in the manner in which they deal with the sentiments that are expressed at those meetings, but ultimately have a responsibility, no more than the rest of us, to provide alternative sources of energy in a safe manner, which can be delivered in order to provide adequate competition and at a rate that is available to all consumers. So, to bring it to a conclusion, then, the question I raise in relation to the legalities of any contracts that have been entered into, if it is such that the companies who wrote those contracts did not say that they had to get legal advice, are they in trouble in that sense? Maybe not. Is there a role for your own representative body, the Law Society? Can it play a part in this? I mean, you know, it's all about informing the public of their rights, of their legal rights and otherwise in relation to a commercial transaction. So finally, you know, there has to be some synergy also between the 5 counties involved in the Midlands region in relation to their own development plans. I know, for example, Westmeath, you know, had no wind energy strategy in their existing development plan and had contravened their own plan to meet with the situation as it arose in recent times. And they have gone about designating cutaway bogs, which is commendable in its own right. We in Offaly, the eastern side of our county, which is predominantly where the cutaway bogs are as well, but obviously there are towns and villages in the midst of that too who are fearful of the impact it will have on them, if any. But ultimately, as the Minister said to you, a lot of this will come down to be tested properly only when full applications are made and adequate reports are cited on the part of those who are making the applications and on the part of the state, who have to have adequate guidelines for them reports to tie in with. So what progress has been made in that regard, and can you come back to me in relation to the legal implications as well?
Senator